All right, so what does it mean when your workers' compensation claim has been denied? Many people receive these notice of denial of workers' compensation claim notices and they completely freak out. This video is simply an attempt to help you have a better understanding of what this denial means. Now, many people become aware that their claim has been denied when they receive what's called a notice of workers' compensation claim denial letter. Please understand that it is very common to receive a workers' comp denial letter. I tell a majority of my clients, especially those that have filed a workers' compensation cumulative trauma claim, which is a claim over time, repetitive injuries as such, that their claim will likely be denied at the beginning. For a quick refresher of the two types of workers' compensation injury claims that you can make, please see my other YouTube videos. This denial means that you will not be receiving any workers' compensation benefits in the beginning. More than likely, you will start receiving these benefits as the case progresses and/or all these benefits at the end in a lump sum. However, every case is completely different. Please remember that insurance companies, especially in workers' comp, are extremely cheap. For example, if you filed a workers' compensation claim for an employer you've worked for 10 years for repetitive injuries to your hands, they might deny that claim, even if it is that straightforward. The insurance companies do this in an attempt to make you go away or try to scare you off. Please do not give up and please do not be scared off. When your claim has been denied, this simply means that you need to connect your injuries to work. A lot of the time, this is done after you filed the workers' compensation claim. Now, going back to that example that I gave before with regards to having filed for your hands for 10 years of repetitive work, what you need to do here is you need to see a doctor that will connect your hand injuries to work. Now, I often get questions with regards to whether or not you must have seen a doctor prior to filing a workers' compensation case. The answer to this is no. You do not always need to see a doctor prior to filing a workers' comp case. While this might be one of the reasons they denied your claim because you have no doctor's report showing that your work-related injuries were in connection with work, this is not required. Most of the time, this is shown usually through an attorney and a doctor's office after you filed your workers' compensation claim and it's been denied. You might be wondering, if your claim has been denied, how you actually see a doctor. Now, what happens is your attorney will set you up with a doctor on a lien basis. So the attorney will look at what injuries you're complaining about and will set you up with a doctor in that medical specialty. Once you start seeing that doctor, the doctor will start producing reports, which are medical evidence for the workers' compensation case. Once this doctor starts connecting your denied injury body parts to your work-related claim, the insurance company will start wanting to get involved, meaning you are now producing evidence that shows that you have in fact sustained injuries to your hands or whatever the body part is in connection with your employment, and the insurance company has nothing to rebut it. Once the insurance company starts getting served with these medical reports connecting your injuries to your employment, they will start objecting to these reports. What happens at this point in time is the insurance company will usually choose to go to a PQME or an AME. A PQME is a panel qualified medical evaluator, and an AME is an agreed medical evaluator. An AME, the agreed medical evaluator, is always the preferred method because this is a doctor that your attorney and the defense attorney agree to. They both believe that this doctor will give a truly neutral assessment of the case and whether or not your injuries are in fact connected to your work. This is in contrast to a PQME or panel qualified medical evaluator, who is simply assigned to us by the court. What happens is the court will send a list of 3 doctors. Your attorney crosses one off the list, usually the most conservative. The insurance company crosses one off the list, who's going to be most in favor of you, and we're left with the 3rd doctor in that specific medical specialty. So here with the hand, 10 years of working, this would be an orthopedic panel qualified medical evaluator. Now, a PQME goes up against your primary doctor. If the primary doctor says that all your injuries to your hands are in connection with work, then the insurance company will hope that the panel qualified medical evaluator does not agree. If the panel qualified medical evaluator and the primary treating physician agree, then that's usually it. That's where that issue is resolved. However, if they disagree, then this is usually a triable issue, meaning this issue over this body part would go to trial. For example, if you also claimed injuries to your stomach, well, in addition to your orthopedic claims, you would also have an internal claim for stomach issues, such as acid reflux or something like that. So you would go to a panel qualified medical evaluator in that specialty. Once you have all the different specialties, then again, it would go to a trial if the doctors aren't in agreement. example again is the orthopedic doctor, your primary doctor, says that all your hand injuries are as a result of work. The panel qualified medical evaluator does not. The internal treater says your stomach issues, acid reflux, are in connection with your medications from work, but the panel qualified medical evaluator does not. This goes to a judge, and the judge decides which report is better. Now, if you choose to have an agreed medical evaluator, an AME, whatever this doctor says goes. There's no battle between the AME and your primary treating doctor. The primary treating doctor's report basically means nothing next to an AME. So you would go to the AME, whatever that doctor says goes. You are able to take his deposition and try to get him to change his opinion. Ultimately, his final opinion is what the judge will follow. Now, if the PQME and or AME are agreeing with your primary treating doctor and a lot of the medical specialties have been finalized in reporting, this is when the insurance company will likely start paying you some benefits, whether monetary or they might be starting to offer you medical treatment. However, it completely depends on every case and what the insurance companies are arguing. Sometimes the insurance companies, even with reporting that all goes against them, will still fight and take it to trial, which they normally lose. However, again, insurance companies are very cheap and they want to hold on to their money and do not want to pay benefits. So again, don't give up. Please keep fighting your case. Be patient. Workers' compensation is very slow. It's a horrible system. It's slow, but if you stick with it, you can ultimately get what you deserve at the end. I hope this video has at least helped you out a little bit. Please see my other videos for additional help.